Good morning, everybody. Thank you very much for joining today. As Heather said, my name is Flora Jago. I'm a senior solicitor in our healthcare advisory team in London. And today we're going to be looking at complex hospital discharges and looking at a few themes around that, practical steps that hopefully will be useful for you all and your teams when dealing with what is obviously an extremely challenging issue. So in terms of looking at what we're going to cover today, obviously we've got our agenda on the screen now. So we'll be looking at some of the data around delayed discharges, so the scale of the problem and the challenge that's facing colleagues in the health sector, the discharge to assess framework. We'll be having a look at some internal discharge policy and processes around that, focusing on the importance of having a really good discharge policy to ensure effective discharge planning and making sure that patients and families and their carers are involved in that, the importance of liaising with other organisations like the local authority. We'll be looking at common problems, so areas that often give rise to disputes, particularly around accommodation and care, and we'll be looking at ways to avert these problems. We'll be having a look at options for escalation, so what to do when, despite the best efforts of everyone involved, the patient or their carers refuse to agree to a discharge. And we'll be looking at the distinction of different categories of patients, so for example, adults with capacity, adults without capacity, and cases involving children. And then we'll finish by looking at a couple of case studies, reflect on some learning points, and we'll obviously have some time for questions at the end. So going to start off by looking at the scale of the issue around delayed discharges. So I'm sure you don't need me to tell you from your experience, obviously, within the health sector, that this is a real issue. And that's despite attempts from the government over a number of years to tackle this problem. The data shows us that delayed discharges have only increased since 2022. The data in March 2023 showed us that the direct cost of keeping medically fit patients in hospital beds had been over £1.7 billion. And that is just the cost of caring for the patients, not the time spent arranging discharge and all those other steps that are needed. Obviously, that money would still be spent if those beds were filled, but it would be spent on patients who need to be in hospital rather than those who are ready and able to go home. In December 2021, NHS England announced a new national discharge task force and this is taken from NHS England's website, to bring together partners from across health and social care to focus on opportunities to improve discharge. In particular, it aims to improve the outcomes for patients who no longer meet the criteria to reside, so they can be discharged from hospital, cared for in more appropriate settings, and to release much needed capacity within acute providers. Had steps following on from that. So in September 2022, the government announced a £500 million adult social care discharge fund, and the autumn statement included £2.8 million for social care. The discharge fund was to assist with enabling the discharge of patients from beds. Then in January 2023, the government said it would give an extra £200 million for extra beds in care homes and other settings, with the specific aim of increasing capacity in post-discharge care and support. And that was for discharges between January and March 2023. However, the data shows us that less than 50% of delayed discharges are actually due to a lack of beds. There's a number of other problems we need to look at, including issues accessing NHS services in the community, poor hospital discharge processes, such as delays in discharge planning, and disputes over discharge with the patient and or their family. And obviously, it's worth noting with this that we have a general election coming up, and so it remains to be seen what further work may be done to tackle this issue from any new government after July. We've had a look at some of these statistics around the sort of scale of the problem, and obviously we've got a visualization of that here. So what you can see on the screen is data from the Health Foundation, which reflects the increase in delayed discharges that's been seen over the years, so going back to 2010. There's a vertical line you can see towards the right of the screen there, and that is because in mid-2020 there was a change in the definition of a delayed discharge. So we can't exactly compare the data from before and after that point. However, you can clearly see that notable increase from 2020 into 2023 in delayed discharges. So the definition before mid-2020 was that delayed discharge was defined as when a patient was identified as ready for discharge by a multidisciplinary team involving the NHS and other professionals such as social care where relevant. Post mid-2023, we're looking at a definition that is when a patient is identified as medically fit for discharge, so no longer meeting the criteria to reside in hospital by the NHS only. So we can't exactly compare those two sets of figures, but you can see obviously there's an incredibly sharp increase from 2020 onwards. So looking at the discharge to assess, this has been in place since March 2020 and features heavily in NHS England's recent guidelines. The aim is to get people home as soon as possible with a focus on same-day discharge. It's worth remembering with this that there's no need for the discharge destination to be perfect or suitable long-term. It just needs to be suitable enough that the patient's needs can be met at that time. However, obviously the discharge does still need to be safe. There was previously, as mentioned, a National Discharge Fund from the 1st of April 2021 to the 31st of March 2022 to give additional funds to trusts to help support that process, but that hasn't been renewed, and therefore it's up to local organisations to fund discharge arrangements, which obviously brings with it certain challenges. So what we can see here is about the pathways available under discharge to assess, and there are 4 pathways. It's notable that they all offer a same-day discharge from the ward, even for the most complex patients. So pathway 0, which you can see at the top there, will be for most patients, and that's looking at discharge from the ward within an hour. They probably need no support, minimal support. They may need still some support in the immediate discharge aftermath to check they've settled back into home. Pathway 1 is where some health or social care support is needed at home. And with that, there is an option to use hotel accommodation for days, but it's specifically not weeks if necessary. So very much a short-term option. Pathway 2 looks at short-term care for rehabilitation or recovery. There's a focus on giving a patient independence to return home. It suggests that those who need a care home placement should go home first, and then a decision about long-term care should be taken once they've recovered from their acute illness. But we do have to wonder how practical that might really be. And then we're obviously looking at pathway 3 as well, which is where a patient should not transfer straight to a care home as a permanent placement from an acute hospital, and that needs the involvement of a local authority, and that's where we're looking for people with bed-based 24-hour care, and it's going to be a long-term question. When we're looking at pathways 1 to 3 in particular, we need to ensure that there's a case manager in place, and that should be provided promptly, and make sure the long-term planning starts straight away. The point of this NHS England model is requiring all organisations to work together closely and collaboratively, and we should have a transfer of care hub, and that can be physical or virtual, to ensure services are linked and information can be shared. And it places duties and responsibilities on all involved in the discharge. So that's the trust, the local authority, social care providers, commissioners, to really work collaboratively there. So just some additional points to have a look at as well around discharge to assess on the screen here that you can see now. So we're looking at twice daily ward rounds where patients are reviewed and then they're discharged the same day. Social care needs assessments and continuing healthcare assessments can take place in the community unless there are safeguarding concerns. It's mandatory to consult any carers. This was always the case, but it's now enshrined under Section 91 of the Health and Care Act from the 1st of July 2022, although that carers assessment itself can take place in the community. For mental health patients, it's important to consult their relevant consultant or their care coordinator as part of that discharge planning. And for patients who are homeless, they should be identified at the point of admission, so identify that early and referred into the local authority's homelessness and housing support team to make sure those provisions are in place. So we're going to move on to our next slide now, which is moving on to have a look at the discharge policy. So really crucial document for a trust to have. All trusts should have a discharge policy. Having a policy ensures that there's consistency and that all staff know what they should be doing when it comes to discharging a patient. It's particularly important that there's clear timelines in the discharge policy, because delays in contacting the local authority and putting in place discharge arrangements are a really common cause of a patient staying in hospital too long. We've got points on the slide there that you can see about what it needs to be covered in that policy. It's really important that the policy is followed, because if a case goes to court, the court could be critical of the trust if the proper process hasn't been followed. That means it's important that there's early planning, that the patient is kept informed, and you're making sure all relevant letters are sent out promptly and to the right people. The policy needs to apply to all discharges, and that's whether the patient has capacity or not. If you're dealing with a child or an adult patient who lacks capacity, it's likely that you'll be having most of the discussions and sending letters to the person with responsibility for making decisions rather than the patient themselves. For a child, that's likely to be a parent or carer, so someone with parental responsibility. And for an adult, it might be someone with a lasting power of attorney or another family member. If a patient is particularly difficult, you're likely to be falling back on the trust policy around escalation, which we'll look at in some of the slides to come. There's also some helpful guidance and leaflets available for patients about discharge on the government website under hospital discharge. There's some resources available there. So looking at the key steps from a discharge policy, the thing to keep in mind is that discharge planning starts from when a patient is admitted to hospital. So it's a process that runs throughout their stay. But obviously you want an idea of how long the patient is going to stay in hospital before taking steps to put support in place. So for example, if someone's going to be in hospital for 3 months, any plans put in place within the first couple of months are unlikely to be current at the point they're ready for discharge. However, it's vital that you come up with a firm plan early enough so that there's time to get the necessary support put in place and resolve any issues that might arise. What we often see in delayed discharge cases is that planning is left until someone is medically fit for discharge, and then we run into problems that could have been tackled weeks or months earlier. Don't assume that it's going to be a straightforward process and that everyone will agree, so factor in time to deal with complications. It's important to hold discussions with the patient and any family members who are involved in their care. Where a patient lacks capacity but doesn't have a lasting power of attorney in place, those family views are not determinative, but it's important to involve them in discussions. If someone has a lasting power of attorney for their family member, obviously their views will carry a lot more weight. For patients who have care needs after discharge, it's important to liaise with local authorities and other organisations to get those appropriate plans put in place. What we often see is that planning consists of sending a relevant form to the local authority, for example, but no direct discussion with those colleagues. That will probably be sufficient for the more straightforward cases, but for complex cases or for those where you anticipate further difficulties arising, it is sensible to open a dialogue with those other organisations and those colleagues early on. If necessary, you can always arrange an MDT meeting to discuss it further and keep that collaborative working going. It's very, very rare that you have a situation where you have a fully fit and able person who just refuses to leave hospital. It does happen, but it is very unusual. Generally, issues around discharge are because there are people who have care and accommodation needs, and there is an issue about how those are going to be met and the level of support that's going to be in place once someone's been discharged. I think something that's really key to emphasize is that with difficult patients, it's important that you are ready to discharge when you say you will be. It risks undermining any escalation process if there's been a lot of chopping and changing regarding when the discharge will happen or what the arrangements will be. So what are some common problems that we see when we're dealing with complex discharges? So the first one is that the accommodation isn't suitable. So accommodation and care are the most common reasons for a patient and or their carers refusing to agree to discharge. And it's worth noting that it could potentially be tied in with existing disputes over accommodation and or care that might be active in the court of protection at that point if a patient lacks capacity. It's not the trust's job to find accommodation or to source a care package, but the trust does still need to be satisfied that the arrangements that are in place are suitable for the patient's needs. So the questions to ask when thinking about, care and accommodation in particular are, has there been a recent assessment of the patient's needs? And do the proposals seem reasonable to meet the patient's needs? Think about whether there are any concerns that need to be raised with the local authority early on so that they don't become a sticking point at discharge if there's particular complexities. And if the patient or their carer raises concerns, make sure they're dealt with so that you have evidence to support telling the patient or carer that their concerns have been considered. For example, it might be if the family thinks 2 carers are required for a patient rather than 1, make sure you have evidence like a report from an occupational therapist explaining why 1 carer is safe and suitable for that patient. Sometimes you do encounter aggressive patients. It is very difficult to deal with, so it's important that you have the trust behavioural policy available to implement as well, and that is applied in line with the provisions in the policy. There might be a temptation to back off because the patient might already be being difficult, but it's really important to take a firm and consistent approach in those scenarios. We're going to have a look now at capacity in the context of discharge, and it's really important that we consider the capacity of the patient that we're dealing with when looking at a discharge. It's important to keep capacity in mind and ensure that you're clear about whether the patient is able to make decisions about their care and their accommodation themselves. If a patient lacks capacity, the person making those decisions is likely to be someone with an LPA or a family member for an adult patient. For a child, it's likely to be a parent or carer, or so someone with parental responsibility. If there are any doubts about about the patient's ability to make those decisions, then you should do a capacity assessment following the requirements of the Mental Capacity Act. we would recommend that that's done at a consultant level if there are already disagreements about the discharge, to make sure that's robust as possible. It's also often useful to seek support of other colleagues. For example, if you have colleagues in your Safeguarding Mental Capacity Act or Learning Disability teams who can support with capacity assessments as appropriate. Capacity changes the approach that's taken when escalating any refusal to leave, which might include the court needing to become involved. So it's really important that we have a clear and accurate position on capacity. If escalation into court is required, which court will depend on the situation about the patient we're dealing with. So for an adult with capacity, we'd be looking at eviction proceedings in the High Court. For adults who lack capacity, we'd be looking at proceedings within the Court of Protection. And for a case involving a child, that would be under the inherent jurisdiction of the High Court. And that's part of the family division. And if we did go to court, it's likely that the court would also want to see evidence of capacity. So it's really important that you have clear, robust and thorough documentation of the patient's capacity to make these decisions. We're looking at a situation now where you have a patient who is refusing to leave. So what do you do next? Referring back to what we talked about earlier about the importance of having a good discharge policy, the escalation section within that will kick in right away as soon as the patient refuses to go. And we'll have a look at what the escalation policy should be in a minute. We obviously always want to avoid resorting to legal action. So the aim is to try and resolve the situation as amicably as possible. However, you do need to be keeping really good records of any discussions happening to make sure that those are available if necessary. It will be a point that comes up when legal action is, there will be a point where it's appropriate to mention legal action, but don't use it as a threat. We want to try and avoid that if at all possible. Don't suggest it early on. It's likely that you'll need to involve other organisations, so try and keep those direct contact channels open, and that'll be much more effective than email. So like we talked about earlier about having MDT discussions with colleagues, for example. Think about if a second opinion is necessary. So, for example, if there is a genuine issue, for example, it's not clear the amount of care that a patient requires in the community, would it benefit from a second opinion being obtained? Although you won't be talking about legal action to the patient, it is important to have that at the back of your mind. So it's important, as we said, that the records are accurate, as they should be anyway, and that full records of all discussions about discharge are kept and they're clearly available in the medical records. And the last point there, seek legal advice early. So come to us early. It may be that there's very little we can do immediately, but we can advise you on the immediate next step and check things are on the right line so that those escalation options are available if required. And it's not just for discharges. We say this to everyone about all kinds of advisory work we do. The earlier you seek advice, the better, because hopefully we can help you avoid reaching a point where legal action and proceeding to court is required. And that's obviously always the aim. If your discharge policy doesn't currently include steps for escalation, then it's recommended that it is updated to include one. The danger of not having an escalation policy within that is that staff don't know what they should be doing when faced with a difficult patient. There's then a delay while people decide what their next steps are. It also risks inconsistency or claims of unfairness. It's really important also to show that the trust has done all it can to resolve matters via negotiation and working collaboratively before escalation to steps like court happens. The policy should provide for a meeting to discuss the patient's concerns and agree a way forward. If there's a dispute over care or accommodation, any other organisations involved in that, such as the local authority, should be included in that discussion. Sometimes there might have been several meetings and they haven't moved things forward. If there is genuinely nothing new to discuss, such as the care package hasn't changed or the concerns have already been explored, it's not essential to have another meeting. However, if there is scope for agreement or if the plans have changed, then we do recommend having another meeting so those discussions can keep going. After the meeting, the patient should be issued with a new discharge date, and it's important to get all arrangements in place to go on that date. As we said earlier, it's really important that you avoid chopping and changing with discharge dates so the communication is clear and consistent and that things are ready to happen on the day the patient has been told they will. If the patient then refuses to go on the next discharge date they've been given, you would then need to issue them with a letter withdrawing their licence to remain at the hospital. This therefore has the effect of making them a trespasser, and it's important to do that or else it could be suggested that they thought they were allowed to stay. So it needs to be very clear that their ability to stay in hospital has ended. Even if the patient continues to say they won't leave, make sure you're sticking to your policy and trying to follow that as far as you possibly can. So we'll now look at, the patient is still refusing to leave. What are our options next? We move on to our next slide. So what do you do at this point? You still have a patient who's refusing to leave despite those steps we've just talked about. So the options here are different depending on whether we have a patient who has capacity or an adult patient who lacks capacity or a child who is in hospital. So for adult patients who lack capacity, they can be deemed to know what they are doing and the consequences of their actions. So therefore, you are able to take a firmer approach. And you can see some options listed on the slide here. We'll look at those individually in a moment. For children or those without capacity, you need to deal with the situation much more carefully, and we would not be looking at any kind of force to get them out of hospital. So if we move on to look at our first option from those listed, so a letter from solicitors. So sending a letter from solicitors to the patient or the person making decisions explaining that they are no longer entitled to remain at the trust is an option in all cases. So whatever the category of the patient is that we mentioned earlier. And you can also make reference to seeking legal costs, which can be a benefit of the approach of writing to them. So it can be used in all cases. We've got the benefits that it's easy and it's cost effective. The downsides, though, are obviously if the patient's already been told that they're trespassing and then that hasn't had any impact, it's unlikely that a further letter is going to change the situation. And it can also inflame tensions and make the situation more difficult. Our next option on our next slide is involving the police. This is an option that would only be for adults with capacity. We would not suggest this is used for children or for anyone who lacks capacity. Once the patient's license to remain on the ward has been withdrawn, they are trespassing. And this is what we said about the letter they'd be provided on their discharge date if they refuse to go a little earlier. Once they're trespassing, in theory, at least, they can be removed by the police. There is no specific or clear legal basis to support this, and it is rare that police would get involved, although it has happened in some cases, and they may not have the resources. It is more likely that the police will be able to persuade the patient to leave than sort of pick them up and throw them out of hospital. Obviously, other risks of this, that it's potentially disruptive to other patients, and there's a risk of criticism for the organisation if something were to happen to the patient immediately after their removal. There are benefits of this, though, in that it's quick and efficient, it's cost effective, and there's no need for staff at the trust to get involved at all. Our next escalation option is about involving security. Again, this is an option that would only be advised for adult patients who have capacity. The advantages of this, again, it's quick, it's cost effective, and there's no need for clinical staff to get involved. There are downsides, though. It's potentially disruptive to other patients. There is a risk of harm to the patient, a risk of adverse publicity for the trust, and in a worst case scenario, it is a decision that could be explored at an inquest if something went severely wrong. Generally, for most, it is extremely high risk, and we wouldn't recommend going down this route for most cases. We would also strongly advise that you seek legal advice before considering pursuing this as an option. The next option we're going to look at is escalating to court. So as we mentioned earlier, there's different courts available for different scenarios. So adults with capacity, adults without capacity, and children. So for adults with capacity, we're dealing with the High Court, and that involves generally less scrutiny of a case in the Court of Protection. For patients with adults with capacity, we're looking at possession proceedings in the High Court. It's a property claim, really, so there's no discussion about best interest, which is what we see in the Court of Protection, and it is very unusual in a healthcare context. For adults who lack capacity and for children, so for adults who lack capacity, we're dealing with the Court of Protection. For children, we're dealing with the High Court's inherent jurisdiction. For both of those cases, the court will be looking at best interests. You will need to have a clear care plan and evidence of how the patient's needs will be met, because there will be much more scrutiny on the process. The court might order a second opinion about what the right steps for the patient are. If it's an adult patient, it's likely that they'll be represented by the official solicitor unless they have another suitable representative. If the family is part of the dispute, then it's unlikely that the family member would be there. A child may be represented by CAFCAS in the proceedings. Generally, it's a slower process to go through court, but you can get urgent hearings when needed. There is also the possibility of having an interim placement pending a final decision through the court process. So looking at the pros and cons of proceeding to court, the advantages, obviously, you have the security of having that court order. There are some cases where you can obtain orders limiting future attendance at a hospital if you're concerned about a patient coming back. But for example, that might say that they can only come in the event of an emergency. It does also give you the potential of recovery of costs. The disadvantages are, though, that it is very time consuming for staff. preparing witness statements, it is also very expensive as a process. And it might worsen relation with the patients, although sometimes we do see examples of where the patient is keen to go to court. The other thing to bear in mind with disadvantages is that with recovery of costs, there is always a question about how realistic that is in terms of getting this back from a patient. We've got some case studies that we'll have a look at now. So there's two we're going to have a look through here. So what we have here is quite a common scenario. So this situation was one where an application was made in April with a hearing in May, with the patient discharged to an interim placement and then a final hearing in June 2018. The official solicitor represented the patient at the hearings, and it was agreed that discharge was in her best interests. The trust provided evidence to the court that all necessary investigations had been completed and that there were no further investigations warranted. It was also confirmed that any medical needs were informing the care planning that was being done. What happened here was that with the court of protection application after that first hearing, the trust was discharged as the applicant because that was when the patient was discharged to an interim placement. The proceedings then continued with the local authority as the new applicant because now the patient had been discharged from the trust. That was on the basis that the remaining issues were about the accommodation and they didn't actually concern the trust. So hopefully we can try and limit the involvement that the organisation has to have on a long-term basis, particularly if interim discharges are available. Our next case study involves a patient, MB, who was refusing to leave because she hadn't been offered a flat in her preferred postcode. You can see some of the background here that she'd been offered accommodation in a different postcode, which was suitable and was available. The trust issued urgent proceedings at the beginning of April 2020, which I'm sure goes without saying, that was obviously the very beginning of the COVID pandemic. The proceedings were dealt with very quickly, although the impact of COVID was a useful factor in terms of the court being very concerned about making sure that hospital beds were available for those who need them. So this is a patient who has capacity. So unlike our previous slide where we were dealing with a patient who lacked capacity and therefore the case was being dealt with in the court of protection, this is a scenario where the patient has capacity. And so rather than approaching the case as a best interest issue, it is purely a property claim, i.e. dealing with the eviction of a trespasser. The case did have to be converted to an injunction due to a ban on possession claims due to the specific factors in place at that point in time. There were hearings on the 2nd, 6th and 9th of April 2020 before Mr. Justice Chamberlain, so you can see the speed at which this case moved. The patient's argument was that requiring her to leave would breach her rights under Article 3, Article 8 and Article 14 of the ECHR, as well as amounting to breaches of the Equality Act. There was still some consideration of whether the care package and accommodation was appropriate, despite this being a property claim, but it wasn't the same process of considering other options that we might see in a court of protection case. The patient's argument was dismissed and an order was obtained evicting the patient from hospital and preventing her from reattending unless she was readmitted as an emergency. The applications for the trust therefore was granted and there was an order for costs. There are precedents for cost orders in these types of cases, although as I said earlier, we do have to query how enforceable those may really be in the long term. So if we go on to our next slide, it's worth looking at some of the comments from the judge, Mr. Justice Chamberlain, about the human rights arguments made in this case and about the resources more widely. Hopefully you've had a chance to read these, but I'll read them out just in case. So in relation to Article 3, it said that in some circumstances, a hospital may have to decide which of two patients, A or B, has a better claim to a bed. A hospital which in those circumstances determines rationally and in accordance with a lawful policy that A's clinical need is greater than B is not precluded by Article 3 of the European Convention on Human Rights from declining to offer an inpatient care to B. The absence of evidence identifying a specific patient or patients who will be disadvantaged does not mean that such patients do not exist. In relation to Article 8, he says, even though decisions to cease to provide inpatient care to MB and to require her to leave plainly interfere with her right to respect private and family life, the interference was justified in order to protect the rights of others, namely those who, unlike MB, need inpatient treatment. So you can see the judge dealing there with the balancing act between the needs of patients who do require that hospital bed and those who don't. Also, it's worth highlighting the reference to the lawful policy in Article 3, which links back to what we were talking about a little earlier, about the importance of having a really clear policy that can be followed by all in the trust and referenced in court proceedings if required. It's worth noting here that a feature of MB's mental health conditions was that she often suffered from extreme distress. Preventing the trust from doing anything to cause distress would therefore preclude them from taking any step other than in accordance with MB's wishes, even if that was at the expense of other patients. The judge does a discussion about resources more generally, and as he says, it's lawful to make decisions about which patients have a greater need for scarce resources, such as an inpatient bed, whether that is in a pandemic or not, which is obviously particularly relevant now. And importantly, it's worth highlighting that specific point he makes, clarifying that the absence of a specific patient or patients who will be disadvantaged if MB remains in hospital where she is, does not mean that those patients do not exist. So it doesn't have to be a named alternative. So just reflecting back on what we've looked at in terms of some learning points here. So it's important to identify potential problems early on. So work from the beginning of a patient's admission to think about discharge. It's an ongoing process. Imagine that there might be issues and build in time to deal with those rather than only thinking about planning once a patient is medically fit for discharge. It's important to work collaboratively with other agencies such as the local authority to make sure that all areas of the discharge are being covered and that everyone's clear on their roles and responsibilities within that. It's so important that you have clear discharge and escalation policies and that those are followed. There needs to be consistency in messaging so that things are being done in line with the policy and that the patient is given consistent information that is followed through, for example, around dates for discharge. The aim is always to resolve the dispute amicably, think about alternative ways to reach agreement, involving those partner discussions to make sure that all points have been covered that need to. And obviously court is available as a last resort, and we've seen what the steps can look like before that. Finally, as we said, it's so important to seek legal advice early on, even if only to check that things are the right track. If seeking legal advice doesn't mean that things will immediately be escalated to court, but we can help you manage things in a way that hopefully means that won't be required, but also such that all the steps are in place if eventually that escalation is needed, though obviously that's something we always hope to avoid. That's the end of everything I wanted to say specifically, and we do now have some time for questions, and Heather will be doing those, so please do share any questions or comments you may have.
Good morning, thank you. In our trust, we have some issues at times with patients who are being offered a DTA bed. And because of the high demand, it's not always in the close location to the hospital itself. And so family and patients then decline that DTA bed because they said they give reasons such as, oh, the cost is too far, or I don't drive, I can't travel there. Where do you stand on that point if a bed is offered by the local authority for DTA beds and then patients and or family, they decline?
So it's sort of an interesting scenario that sort of reflects one of the case studies we were looking at about suitable accommodation being offered, and it might not perhaps be in the preferred location. Obviously, we always want to try and reach agreement, but it's important that, you know, those options are available. I think it sounds like a fairly complex scenario if you've got some specific cases there. If it's some specific things that we can discuss in more detail, I'm very happy to deal with that afterwards, because obviously specific cases may be better discussed that way. But obviously, we're always trying to reach agreement. To work with those partner agencies as the key points we said, and see if there are beds closer available, see if anything come up. But obviously, if that is the only available option, see if resources can be mobilized to help work with the patient to agree that. And then obviously we do have those escalation steps that can be followed if needed. But obviously seeking advice on that early is probably going to be helpful, particularly if the patients are sort of refusing to go and you've got complex scenarios with the family members as well. But obviously it is a challenging situation, particularly, you know, when it's not ideal for anyone if we're saying this is the only thing that's available and it's not in the patient's preferred location. But obviously if there's particular points on cases like that that you'd like to follow up with, please do get in touch and we're happy to have a look at that.
Thank you.
Thank you. We do have something in the chat box now. If someone lacks capacity to consent to discharge, however, medically fit for discharge and suitable placement identified in the community, but they refuse to leave, is it the LA or trust who would make a potential COP application?
So it's going to depend on the specific scenario and the specific circumstances of that case. If the patient is in a hospital bed in your trust, it's probably most likely that the trust will lead on that in the first instance, because the trust's priority is obviously to get that bed back and back available if the patient's medically fit. I would anticipate, though, that if there's accommodation arrangements and the local authority are very involved in the discharge planning, you might be looking at a joint application. So trying to work collaboratively, because it may be that if issues continue once the patient is in the community, once you've physically got them out of the hospital, you'd be wanting to see if the local authority can take over that application, like what we saw in one of the case studies. So it's likely to be the trust leading on it in the first instance, but obviously, hopefully with a collaborative approach, the local authority part of those proceedings, because obviously if they're in charge of those placements in the community, then that's going to be very relevant. But it will depend on the specific circumstances ultimately.
Would you involve an IMCA if someone with an LPA wasn't possibly acting in a patient's best interests, the patient lacking capacity, or would you refer to COP straight away?
So an IMCA is always a really helpful thing to consider where you've got a scenario. So for those of you who may not be so familiar with this term, it's an independent mental capacity advocate. So it's always a useful thing to do. And I mean, it's obviously going to depend on the urgency and the time frame you're working to. But with any court process, we always want to try and see what steps can be taken to resolve the issue before proceeding to court. So obviously, if involving an IMCA is something that's going to be useful for that, that's always something to consider. But it's going to depend on the specific circumstances. But it may be that, ultimately that escalation to court is still required, but it can be useful to have that if there's concerns about someone with an LPA. And if you've got someone with an LPA who you think isn't acting in the patient's best interest, it does sound very likely that escalation to court would be required ultimately. But obviously, that would always be dependent on the circumstances of the case.
Thank you. And a follow-on is, how long does it take for a COP for an inpatient who lacks capacity and, for example, their families refuse discharge?
So the COP process can vary massively. So it can, as I think we mentioned on the slides, you can have urgent proceedings and urgent orders if needed, or the proceedings can go on for months. It really depends on the time frame that's working to, and is there a case for urgency? Is there real urgency in the proceedings? But it really, really depends on the circumstances of the case and why the time frame that's required and what the basis for that is. Is it clinical, for example? What's the reason that discharge needs to happen in that time frame? It does take a bit of time to put the application together thoroughly, but that can be done very quickly if needed. So, it really will depend on the circumstances of the case.
There's a question more to the wider audience here. With the duty to refer for homeless patients, what is this the law? What do other trusts do with homeless patients, please?
So I suppose just dealing with the first part of that, and obviously we can open it to the floor in terms of the second part. It's a really interesting question, and we can have a look into that and come back to you in terms of the specific legal responsibilities. Obviously, what we're looking at is about best practice in terms of discharge arrangements and making sure you're working collaboratively with those partner organisations and making sure that homeless patients with those specific accommodation needs are referred early on is a really important part of that collaborative working. We can look into that and come back to you, but obviously interested to hear what other people's experience might be from that, as the question asks about.
Yeah, I was just going to say, well, I had a scenario, but also in terms of the homelessness, I work for a children's hospital, so and that is a recurring issue we have, that families are homeless on admission, sometimes new to the country or new to the city, and we do refer in. We work with the relevant housing solution teams within the various areas and refer into them. But yeah, the issue that we see here, obviously, is in regards to where parents are objecting to children being discharged. And I've got two scenarios at the moment that are similar but slightly different. So where the current properties they live in have both been deemed unsuitable due to the level of change in physical presentation of the children since admission. In one scenario, the house they own could actually be adapted to meet this child's needs and has been assessed, but the family are refusing to do this because they don't like the plans and feel that it will impact on the look of the house too much and it's not what they're happy with. So we're refusing to do that. And the other one is where it's a private rent level of repair, but they're refusing to engage with the compliance teams to look at addressing the disrepair so the child could go home, because they don't want to, they know the landlord, and they don't want to do that. So just wondering kind of advice on steps where solutions are offered to families, but actually they're being quite obstructive in, and all the relevant social services and social workers are involved. We've kind of all done that, but they're still quite obstructive.
It's a really difficult scenario, and I do really empathize that. And it's something that we do see not uncommonly, cases involving children where the parents are essentially the block to the discharge, particularly if you've got children with very complex health needs, because obviously there's a huge number of things that go with that as well. I think obviously that partner working is going to be really important, particularly involving the local authority and their social services where that's relevant. For kind of, it sounds like there's kind of some specific complexities to those scenarios we probably can't go into too much detail here on, but if you are particularly concerned by those, please do get in touch and we're happy to kind of have a separate conversation about those. It sounds like you've got a few quite difficult scenarios there and it's sort of doing all the right things at the moment by the sounds of things. So very happy to follow up and have a separate conversation about those if that would assist, because it sounds like you've got something quite challenging that you're looking at the moment there. But I do, it is something we see a lot, and I've seen a number of cases before about where you have essentially those parents obstructing it, and it can be incredibly challenging to try and resolve those. So yeah, we're very happy to try and support with that if we can. But it sounds like you've been taking the steps possible, but it's going to try and involve, really working with those partner things. But if there's more specific questions on that, then please do get in touch. We can follow up on that.
Thank you.
Do you have any advice about what to do if there seem to be very limited beds which can accept a patient on discharge, because there are too many risks with them having a PEG tube and the care facilities cannot cope with managing an NG tube?
Yeah, this is another really common scenario that comes up, which is about when a patient has very complex or very specific health needs that can't be met by a number of organizations. It's something that I know is very common. I think it's going to involve making sure that all of those partner organizations are involved in conversations and that everyone is kind of playing their part within that. So health, whether there's commissioning involved in looking at having to fund specific arrangements if there's nowhere currently that can meet that patient's needs, potentially looking further afield. But it is very challenging, and it is something we see a lot in terms of when patients are being discharged with, as you say, specific requirements like a PEG tube or NG feeding. They can be really complex in terms of whether providers are able to meet all of those needs rather than just being able to deal with some of them. So making sure all the right people are involved in those discussions and working together to try and resolve that is going to be really important, particularly those other organisations like local authority commissioners, that sort of thing. But obviously, as I said earlier, if there are specific things on what sounds like it might be quite a challenging case you may be dealing with, please do let us know and we can have sort of a separate conversation about that with a bit more detail about obviously, the specifics of that.
My point was just on the back of Anita's question in the chat, the second half about the duty to refer. So our trust up in the northeast, obviously, we identify the patient's need for homelessness and complete the duty to refer. Obviously, if there's no kind of further social care needs that would require maybe a bit more of a supportive placement, obviously we can look at that if they need a care package in place as well, provided from local authority. But if it's just a case of needing housing on discharge, obviously we complete that duty to refer. But the main point is that on our duty to refers up in the northeast is that obviously the patient needs to consent to that. If the patient doesn't consent, then we kind of submit that duty to refer, and obviously we would then look at the capacity issue. And if they do have capacity, then it's an MDT decision involving kind of our trust's kind of legal team and senior people within the trust to look at kind of, homeless discharge without the support because the patient's decided not to be involved with that service. We also hold kind of bi-weekly housing meetings with our homeless providers within our trust as well to kind of talk around cases as well, and they can offer guidance.
Is the discharge to assess guidance statutory guidance?
So it's guidance from NHS England that looks at the funding and the frameworks on that and how those discharge policies should be being followed, those discharge arrangements are set up and sets out the requirements for those. The specific statutory basis for that we can have a look at and come back to you on if that would be helpful, but it's guidance from NHS England that sets out those requirements and obviously ties in with the funding that goes with that we looked at the beginning as well.
My question's about legally conveying adults who lack capacity from hospital to care homes. If a patient has a DOLS in place, or sometimes they don't even have a DOLS in place, and the best interest decision has been that they need to be discharged to a care home, and they're disagreeing with that, and at the point of discharge, they're not wanting to get into the transport, or they're being cajoled into the transport. What I appreciate that the adult social care can apply for a conveyance order. I've been involved with a patient where that happened, that delayed discharge for several weeks while that was put in place. But what is the legal, how do we legally convey people? Often I see people discharged to care homes that actively saying they don't want to go, and they're moved from hospital to a care home. The DOLS ends at the hospital grounds. How do they legally get conveyed to a care home without everyone needing to have a conveyance order applied for, or is that what is supposed to happen?
I think if we also look at that as kind of a bigger picture in terms of, not just they're sort of refusing to go, but it sounds like that's essentially the patient being in opposition to the discharge if they lack capacity, and that still being not in line with their kind of expressed wishes. So obviously the specific moving them from the hospital is obviously going to be an aspect of that. It's going to depend on the specific circumstances of the case, what legal frameworks are already in place. For example, patients who may have a deprivation of liberty order in place, and what the specifics of that are, patients who might be under the Mental Health Act. So those specific considerations need to be looked at, and it would need to be specific advice on that situation. But it may be that, if it's a patient who lacks capacity and is essentially refusing discharge, that does involve escalation to the Court of Protection. And obviously, when looking at discharge planning, the Court Protection, as we said a little earlier, is a high level of scrutiny. And one of the things they will be interested in is, okay, specifically, how is this discharge going to be facilitated? So care planning, which then, you can seek authorization for around the steps to facilitate that actual physical transfer as well. So it's going to depend on the specific circumstances, what the existing frameworks are. But obviously, it may be that there is Court Protection involvement needed there as well.
Thank you for that.
We've obviously talked about some patients going to care homes. This question is, if a patient is admitted from a nursing home and the nursing home refuses to accept the patient back, even though there are no changes to the patient's functional abilities, what can be done to discharge this patient?
It's a really interesting question. I think obviously going to present quite a challenging scenario. I think this is a big one in terms of where we're going to be looking at the involvement of other organisations. So who's funding that placement? Is the ICB involved? What's the local authorities' involvement here? And trying to kind of have a coordinated approach. If the patient lacks capacity, it may be that there is eventually escalation required to involve the Court of Protection if there's issues around discharge. But I think in the first instance, it's going to be working collaboratively with all the, the organisations involved in the arrangements for that placement, and trying to see what the issue is in terms of the patient being reaccepted back into the nursing home. For example, if that's something that's funded by an ICB, looking at what the issues are around that. Is there a way they can be managed? Can we try and have discussions, constructively with colleagues about that, identify the issues, and therefore how to try and work together to resolve those? But it may be that ultimately some escalation is required depending on the circumstances of the patient and what the reasons are for why that acceptance back into the home isn't happening.
As an OT, I found it always frustrating that we only get referrals to AX for discharge at the point someone is declared MFFD, medically fit for discharge. Therapies or others involved in a DC process should be requested as soon as someone's admitted to hospital, really.
I can see, I think Diana, whose question that was.
Oh, yes, sorry.
Yes.
AX means assessment. I'm really sorry. I'm guilty of using
Don't worry.
NHS acronyms.
I thought it was probably assess or assessment, but it's very helpful to have you clarify. Thank you. Yeah, I suppose as I completely agree in terms of, something to think about in terms of working collaboratively, and it's something to think about with discharge policies as well, in terms of if you can set out within your discharge policy, what we talked about really making sure that discharge planning is happening from the beginning. Because, the problems come when you have the patient, as you say, who's medically fit for discharge. And those steps aren't all in place, because also I think in terms of escalating and when patients maybe have concerns or objections to leaving, it is not helpful for that if the patient knows that they're actually ready to go home, but they're being kept in hospital because of delays from the hospital side, because I think that does slightly weaken the position in terms of if you end up with a situation where the patient's refusing to go for their reasons rather than because the hospital thinks there's a reason they can't. But yeah, it might be something to think about in terms of if you can you know, share learning within teams, and kind of if there's case examples, can you work with colleagues about, you know, a checklist of things they need to be thinking about when planning discharge and making sure, you know, OT and things like that are considered within that, something that can be reflected in the discharge policy about the kind of steps you need to be working through, almost like a kind of checklist about when planning a discharge, what can be done about that.
Yes, and one of the things that we did do, particularly during COVID, so we had a matron's checklist. And what it did is it counted down to the time of expected discharge. So we would always identify an expected date of discharge, but what we would also have is a checklist. So the checklist would say 1 week before discharge, have you checked X, Y, Z? I think it's 48 hours before discharge. Have you checked? So is the prescription done? Is the TTAs done? Discharge letters? Have the family been informed, kept informed, etc., etc. And then on the final day, you've got that final checklist, and that's always helpful because the whole MDT has to be involved. And I would hope that at the MDT meetings or board rounds, that everyone is kept informed as to what's going on with that particular patient. But sometimes miscommunication do happen, particularly where you've got a ward where lots of specialities are contributing. So just a thought, if you can put in place a checklist, it's always helpful.
Yeah, and that's a really good idea, actually, rather than just kind of having a list of things that need to be done, having it in terms of, you know, that countdown. So saying, you know, 4 weeks out, have you done this? And obviously making sure within that you've essentially factored in time for things to go wrong, or to be, you know, what we said at the beginning, really like not basing your timeline on the assumption that everything goes perfectly smoothly, having that time built in. That's a really helpful suggestion. Thank you.
And no duplication either. So, you know, it's very clear who's doing what. So you can have, I think it's the time frame, the checklist of jobs, tasks that need doing, and then who is going to do it. And then there's a bit of accountability there as well. It's very, very helpful, very clear. And always sat, when we had the paper notes, it always sat at the front. Unfortunately, we've moved to electronic notes, so you've got to find a way of keeping that going in terms of practice. So, yeah.
That's really helpful. Thank you so much for sharing. That's a really, really useful point, I'm sure, for colleagues as well.
Thank you.
Thank you very much all indeed. Thank you.
Thank you, everyone, for coming along and for sharing your contributions. It was really useful and informative discussion. So thank you, everyone, very much.